Okay, we're on the record in cause number 328-496 and cause number 328-712. Both cases are styled the state of Texas versus Carrington Cyrus or Cyrus Scott. Is that your full name?
Yes, sir.
How you doing, Mr. Scott?
All right, Mr. Miller.
I'm doing fine. Mr. Scott, you're here with your attorney, Mr. Cobb. Your case is on the court's announcement document. Mr. Cobb, you have an announcement you'd like to make?
The only thing is, Your Honor, we have the discovery on the theft case and some part of the discovery on the attempted burglary, which I don't understand. Part of the stuff, we really need to see the video for the attempted burglary too. I'd plead the theft case tomorrow, but the problem with the attempted burglary is, there's some things about it that don't even make sense.
So you haven't completed your discovery, that's what you're saying?
That's what I'm saying. And also too, I need to know the identity of the co-defendant.
Okay, now, Mr. Cobb, how much time do you need?
Probably 30 days.
Okay, we'll reset it for 30 days.
Yes.
You can get your reset. Mr. Scott, could you give us a date?
5/21.
5/21?
Yes, sir.
Okay, it's gonna be reset to May 21st of 2021. Mr. Scott, you can get your reset from your attorney. Once you get your reset, you'll be free to go and you have a blessed day. And Mr. Cobb,
What
once,
about the first case?
The theft?
Yeah,
that's on all two cases, gonna be reset on the same date.
yeah, I remember you said in the day.
Okay, but Mr. Scott, both your cases are gonna be reset on the same day.
Okay.
Okay, so get your reset from your attorney. Once you get your reset, you'll be free to go and you have a blessed day. And Mr. Cobb, get your reset and you'll be free to go as well. And you have a blessed day.
Thank you.
You're welcome.
Your Honor,
Yes,
I've been in touch with Mr. Gilthorpe this morning, and he is currently on his way. He had to do the jail docket for County Court at Law 3, but he's on his way, and I think he might be also doing an appearance for Mr. Galmore because Mr. Galmore is currently teaching a CLE
Okay.
course.
okay, that's fine. Okay. Okay, we're on the record. Is Cassie Kerbo? Eight,
Mr.
three-
Moore, Tyler Moore, he's on your Zoom.
She's gonna do all of it, okay. We're on the record in cause number 317-528, cause number 317-596, cause number 317-626. All three cases are styled the state of Texas versus Tyler Moore. Okay, Mr. Moore, how are you doing?
I'm doing well, Your Honor.
Okay, Mr. Moore, thanks for being patient. Your attorney, Mr. Galmore, I guess is handling another matter. And however, he has his law partner here, Mr. Jared Gilthorpe. Do you have any objections to Mr. Gilthorpe standing in for your attorney?
No, Your Honor.
Okay, Mr. Gilthorpe, do you have any, an announcement you'd like to make?
Yes, sir. We'd like to continue this. Mr. Gilmore's unavailable this morning. He's a presenter in a continuing education class.
Okay, so, Mr. Moore, your case is going to be reset. Give us a date, give us a date. How much time do you need, Mr. Gilthorpe?
Just a normal reset, 30 days.
Normal,
will be fine.
okay. Okay, Mr. Moore, your case is gonna be reset to May 21st. Please stay in contact with your attorney. And this will conclude your case. Again, thanks for being patient. You're excused and you have a blessed day.
Thank you, Your Honor.
Okay. And, Mr. Gilthorpe, are you ready on Cassie Kerbo?
Not quite. She's here and I'm here. If I can have just 3 minutes.
Okay, we get ready.
Can we get her after Jack?
Yeah, that's fine. Ms. Ramos,
Yes, Your Honor.
okay, we hear on, Mr. Jack Lawrence has a motion on a Mr. Glenn William Fink in cause number 324442.
Yes, Your Honor.
Okay, are you ready to proceed? Are you gonna, come down here?
Give me just a moment. I have a witness as part of this from the county jail. And let me see if she's going to appear on Zoom or if I'm going to have to come down there in person and have her appear another way. Give me just a minute.
That's
Your-
fine. Okay, just keep it call it. Why don't you come on up? Okay, we're on the record in cause number 324442. The case is styled the state of Texas versus Glenn William Fink. We have Mr. Fink, is that your full name?
Yes, sir.
How you doing, Mr. Fink?
I'm all right.
That's good. Mr. Fink, you're here represented by your attorney, Mr. Jack Lawrence. Mr. Lawrence, how you doing?
Just fine, Your Honor.
And the state is here represented by Assistant District Attorney, Mrs. Ashley Ramos. Mrs. Ramos, how you doing?
I'm doing okay, Your Honor.
And we also have another Assistant District Attorney, Mr. Raymond Shear. Mr. Shear, how you doing?
Doing good.
Okay, Miss Ramos, you had a matter that you'd like to bring before
Yes,
the
Your
court?
Honor. I had been in contact with a Sergeant Granger from the jail, and she was going to come over to testify as to my, it was going to help with the response for the motions that have been filed by Mr. Lawrence, and kind of explain some facts from the jail standpoint on that. She was available when I spoke with her at 9. She was gonna try and zoom in from the jail around 10:15ish. She responded to me and told me that they only have the 2 computers out there and that they were about to both be tied up with meetings. And then I told her we would see where things were when you were ready to call the case. When you were ready to call the case, I immediately reached out to her. I haven't heard back from her. I've called her twice and haven't been able to reach her. I don't know if she's gone to her lunch, if she's stuck in one of the meetings. I'm not sure, but I'm just gonna ask if we could have maybe a possible reset on this. I understand if not, I've told you what I was intending to introduce with her. I'm prepared to argue the motion if you would like to go forward. I just thought it might help you with your decision on it if we brought someone from the jail that could testify to their records.
Could I reply just briefly?
Okay,
Your Honor, if you'll review the motion, the first amended and supplemental motion to dismiss, it also could be just for credit for time served, it could be either one. Your exhibit attached to the motion are the official records of the Jefferson County Correctional Facility for the time period that Mr. Fink stayed there. And he also stayed in Chambers County just briefly for 3 or 4 months. But the point is, he was arrested.
now, Mr., are you going to argue the case? I mean,
It sounds like he's arguing.
Let me put it
Well, let me
this
do
way.
this here. Let me do this here. You know,
Look at what,
hold
look at your
on,
motion.
okay, let me do this here. I mean, people can file motions all the time. I mean, records have to be properly authenticated. You have to have custodian record. I mean, there are ways to get records in. I mean, we just can't just say, I put it in my brief and the court just take it like, So my point is, the state is requesting a continuance on the matter. And what is your response to that?
There's no purpose in the state taking a continuance. These are official records
Oh,
of
okay.
Jefferson County.
But she stated what her reason was. It's like a missing witness. A witness is unavailable at this time.
The witness has no purpose in this case.
Well, I understand that you can present your case the way you see fit. They can present their case the way they see fit. So
I understand that.
So she think it's necessary for her to have this witness. You think it's necessary for you to, present your case your way. And so now this is a pretrial motion, right?
No, this is not a pretrial motion.
Okay.
He served all his time as
Listen,
well as any possible
is there
time.
a judgment?
We,
Has he gone to trial?
no,
So this is before trial, isn't that correct?
yes. And in
Okay,
fact,
that's all I was asking.
let me give you this letter that the previous district attorney sent me. She was
Well,
going to give him credit for
okay.
time served.
Listen, well, Okay, let me do this here. You know, first of all, the court does not get involved in any negotiations between the district attorney and the defense. Okay?
She said if he has time.
If he has time, sir.
Okay. Now listen, Mr. Lawrence, the court does not get involved in any negotiations between the state and the defense. Okay? And if you got a case that says that the court has to get involved in negotiation, you need to show it to me.
This has nothing to do with negotiation.
What credit for time served has to do with it?
He served all the possible time.
You
as
still
well as
negotiating,
fine
you
time.
still negotiating with the district attorney, aren't you?
It's over. There's no
Is
negotiation.
there a judgment?
No, Your Honor, there's no judgment, but he has served all the possible time as well as any possible fine.
Okay, well, listen what I'm saying, Mr. Lawrence. The court does not get involved in any negotiations between the state and the defense.
If you want to view it that way, that's fine, Your Honor, but
Well, that you,
it's a moot point. Everything is moot.
well, the court does not get involved. This is a pretrial motion. You're asking the court to make a decision on an issue. You ask for, first of all, you're asking for a non-protunct. Non-protunct corrects errors in judgments. Is there a judgment?
No, Your Honor, but it is possible to do a non-protunct in this, with this issue.
How you gonna do a non-protunct if there's no error that has occurred?
Your Honor, the Court of Criminal Appeals, I cite numerous cases. where
And
the
all of
Court
these
Criminal
cases that you
Appeals-
cited are what? Post-conviction cases, post-judgment cases,
Not
right?
all of them. There are cases where there are cases like his, where they have already served all the time that they
But the
could
court,
possibly serve.
but non-protunct is an error in the judgment.
Normally,
So, at this point, if the state would like to, do you need some more time to contact this, to hear from
If
your,
you would like to have the hearing today, I can try again to call out, I can call the jail's phone and maybe they can give me insight on where she's located. It might take me about 20 minutes, maybe, to get some information.
okay, I mean, we
Or
still,
if you would like to reset it to another day for a hearing, I understand as well.
he has a job now, Your Honor, and he's on bond.
so what you're saying is you want to take care of the matter today?
If at all possible, because of what it is. So there's nothing to it.
You want the time to see if you can reach out to your witness?
Yes, Your Honor, and if the court would like me to go forward without her, I'm prepared to argue either way. I just thought it would help the case a little bit.
Well,
So,
It's up to you. If you want to just if you want him to present his motion and you argue, that's fine. If that's how you want to do it, the court can't tell you how to present your case.
give me 5 more minutes, Your Honor.
Okay, we'll give you some more time. Everybody just have a seat, and she's gonna try to reach out to her witness.
Just have a seat back here.
Okay, Mr. Gilthorpe, are you ready?
Thank you.
Okay. Oh. Okay.
hold on.
Sergeant Granger, how are you doing?
I'm all right, and you?
I'm doing fine. Just hold on a minute.
Okay.
Uh, okay. We're back on the record in cause number 324442. The case is styled the state of Texas versus Glenn William Fink. Mr. Fink is present in court with his attorney, Mr. Jack Lawrence. The state is present with Assistant District Attorney, Mrs. Ashley Ramos, and Mr. Raymond Shear. Mr. State has before it in cause number 324442, a first amended and supplemental motion to dismiss or alternatively for non-protunct order bestowing all credit for time served, which was filed by Mr. Lawrence in this case. And also accompanying this motion is a defendant's brief or motion to dismiss or alternatively for a non-protunct order bestowing credit for time served. Mr. Lawrence, are you ready?
Yes, Your Honor.
Mrs. Ramos, are you ready?
Yes, Your Honor.
You may proceed, Mr. Lawrence.
Your Honor. Mr. Fink, you've been arrested for offenses on the same day back in 2018. Arrest happened the same afternoon, really. He was arrested for aggravated assault and possession of Xanax.
Object, possession of Xanax is not the proper term of the offense arrested for.
Yes, it's the same.
We call it alprazolam, Your Honor.
I object again, Your Honor. I believe looking at what the arrest screen shows for that day, it was possession of penalty group 3 is what he was arrested for.
Okay. I was just wondering, is that door open in that room? Can
It
you-
is. It's close.
Okay, that might be a little bit better. Okay, now, Ms. Ramos, what were you
To
saying?
make my objection more specific, Mr. Lawrence is bringing in facts in a case, and he's the attorney in the case, and he hasn't brought a witness to present the facts. He hasn't brought records that have been authenticated to show those facts, and
I object.
clearly there's a
These records.
Hold on, she stated her
a
objection.
dispute between the facts on the case.
I object.
Okay.
These records are authenticated. They're official records of the
Okay,
Jefferson County Correctional Facility.
now, Mr. Lawrence, predicates have to be laid in order for records to come into evidence. Okay? So your objection is, I think her objection was that what you were stating was not an actual offense. Is that correct?
Yes, Your Honor.
You were stating that he was charged with having Xanax, but that is not an offense.
Let me show
The
you.
offense is different. It could be possession of a controlled substance, penalty group 2 or penalty group 2A, or it's not the name of the drug that a person is charged with.
All right, I understand that, Your Honor. If you will look on the jail records,
he was,
I'm gonna object. He's
jail.
not authenticated the jail records.
Okay,
he was
objection
jailed for-
sustained.
Your Honor, he was in jail for possession of a controlled substance, Class A.
Okay.
That is in the jail records.
Okay, I
It
think that's
is
all she
correct
wanted
that-
you to state, is that the proper, offense.
It is correct that these records were faxed to me. They, with a cover page. But I guess you could criticize me that I do not have an affidavit with them verifying them as official records. No, I do not have that. These are only fax pages, the same fax pages I received over the fax. And as well as the letter I sent them requesting the records. I guess they could be objected to for not being authenticated on that ground, but they are the exact records of the Jefferson County Correctional Facility. And I forget how I was going to originally argue that. The matter is, all right, he was arrested and charged on the same day here in Jefferson County for possession of a controlled substance, Class A, and for aggravated assault. The aggravated assault charge was, he served his time in jail. During jailing, he was in County where there was a pending charge for family violence. For that there, then Chambers County dropped that charge around June 5th of 2019. And then Jefferson County Jail, and the aggravated assault charge he was originally charged with here in Jefferson County was dismissed without any trial on September 9th of 2019. Therefore, because he was also serving the sentence for possession of a controlled substance, Class A, served, there was no conviction or anything on these other charges that he was serving. So he has served approximately 13 and a half to 14 months on the Class A misdemeanor charge of possession of a controlled substance. 12.21, sub 2, his confinement in jail cannot exceed 1 year. So he has actually been in jail for over a year. He was actually physically in jail for over 1 year on the charge of possession of a controlled substance. So if you calculate the fine that if you say if you allowed him to serve the extra 58 days on his any possible fine, he has served the equivalent of $5,800, which is above the maximum possibility of $4,000 fine. And he's also indigent in pretty much without any available funds to for that matter. So all possible time has been served, all possible fine has also been served out. And you have the timesheets from Jefferson County Correctional Facility, not from anywhere else. And we're that under oath, as well as a controlling law on these issues before you now, Your Honor. And after our last time we came to court, I asked if I could do a brief, and I have since done a brief. Around 80% of the cases that state that he is required to be awarded back time credit in our situation or en banc opinions of the Texas Court of Criminal Appeals. I have requested a motion to dismiss since there is no way he can be held in involuntary servitude any further. We could also, there's no way the court can sentence him to a fine or to jail time at this point in time because his sentence has been served. We would also go with anything else that would get him his freedom. So he would no longer be on bond for these alleged offenses, or this one alleged offense of possession of a controlled substance. I mean, that's what I would request, Your Honor, is that we simply review this with common sense and not any hyperbolic projections of how things run at the jail or anything else. We just can go by their records and give him credit for the time that he's already served. And that's my only request. I mean, to me, all the issues in here of any possible sentence are moot at this point in time, Your Honor.
First, I'll call Sergeant Granger.
Okay, Miss, okay, what's the full name?
Sergeant Granger.
Could you state your full name?
Sergeant Granger, Sergeant Stacy Granger.
Okay, Miss Granger, would you please raise your right hand? Miss Granger, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Miss Granger, you may put your hand down. And just for the record, Ms. Granger is testifying via Zoom, and the State Assistant District Attorney, Mrs. Ramos, is in court. Ms. Ramos?
Would you ask her? Ms. Granger,
Yeah.
could you spell for the court reporter your first name, Stacy?
Yes, Stacy. Stacy.
And what's your position at the Jefferson County Jail?
I'm a sergeant in bookend.
And as a sergeant in bookend, are you responsible for the calculations of defendants' credit in cases?
Yes.
And are you familiar with Glenn William Fink?
Yes, I pulled his jail cards. That's what I'm holding in front of me.
Okay. And we heard some facts coming from the defense attorney on this case. Could you tell us, in reference specifically to cause number 324442, how the jail calculated his time in that case?
Okay, in this case, calculating the time for the controlled substance possession class A, warrant number 324442, we go in the DA file and see when the offense took place. And then it brings us to the first time he got arrested on that charge. But what we're looking for to see with the warrant number, and from the first time he got arrested, we're looking to see how many days he did altogether on those charges. So when I go in the DA file, I see that he was arrested on 7/12/18. It was a brand new charge, so it was on accusation. And for misdemeanor accusations, that's 3 days. So his accusation date was up on the 15th. So from 7/12 to 15, that's 3 days that he will be given credit for. The second time that he came back to jail was on 12/23/19, which he got out on bond the next day. So that's a total of 1 day that he did on that charge. So altogether, that's 4 days good time that we would calculate that he did on this particular charge.
I'll have the witness.
Okay, Ms. Granger,
Yes.
Mr. Jack Lawrence is gonna be asking you some questions.
Okay.
Yes, Ms. Granger.
Yes.
Do you have the printouts from the Jefferson County jail records before you at this time?
Yes.
Okay. Do they show Mr. Fink was arrested for possession of a controlled substance, penalty group 3, July 12, 2018.
I don't think she heard you.
It went in and out. I'm sorry. Can you repeat that?
Do your records show that Mr. Fink was arrested for possession of a controlled substance, penalty group 3, on July 12th, 2018?
Yes.
All right. Why do you contend that he only got 3 days credit for his jail time? Well, let me rephrase that. Do you agree that he stayed in jail until his discharge after he was arrested for this? Do you agree that he stayed in either Jefferson County Jail or Chambers County Jail continuously until at least September 9th of 2019, after his arrest on the 2 charges that he was held in Jefferson County on?
Your Honor, I'm going to object to that line of questioning. It's not being specific as to which case, and as Mr. Lawrence himself pointed out, there are multiple cases that Mr. Fink had been in custody on, and we're only here regarding this case.
Your Honor, my question did not concern specific cases. It said,
That's why I'm objecting, Mr. Lawrence.
it said, does her records show that he served in Jefferson County Jail continuously from July 12th of 2018 until he was released on or about September 9th, 2019? Does the records show that? That's
Okay,
my question.
Okay, objection overruled. You may proceed.
Yes. Let me rephrase the question for you so you get it this time. Did Mr. Fink serve time in Jefferson County Jail from the date of his arrest on the possession of a controlled substance, Class A, continuously until at least about September 9th of 2019? Did he serve time in Jefferson County Jail continuously during that time period?
I'm going to object because the question was very unclear, and he's trying to trap her into admitting what she's already testified to, which is that he only has served a specific amount of time on this case.
Could you rephrase your question?
Yes, Your Honor, I will. Officer Can you tell me, according to the jail records that you have, if Mr. Fink served time in Jefferson County Jail from the date of his arrest on July 12th, 2018, for or among other things, possession of a controlled substance, penalty group 3. Did he serve that time continuously until his release on bond on September 9th, 2019?
I'm going to object, Your Honor. It's asked and answered. She testified to what time he had served on this case when she testified in my line of questioning.
Objection, no, objection overruled.
Would you please answer that question?
We don't have record of Chambers County time. When our time stopped when he transferred on the other charges, it stopped when he transferred on July 20th, 2018. Now, as far as the accusation, when he came in on the possession charge, you only held for 3 days, 72 hours on accusation because it's a brand new charge, which that time started 7/12/18, and his accusation was up 7/15/18. So after 7/15/18, his accusation was up, so that charge was no longer on him because the accusation was up.
Why are you saying he was only being held on an accusation on that offense?
It was a brand new charge. When you come in with a brand new charge, an affidavit, you get accusation. Felonies, you get 72 hours. The weekends don't count, so that extends the felony accusation because it was towards the weekend. But on misdemeanor, it's straight 72 hours. Weekends count. The DA has 72 hours to pick up that charge. If they don't pick it up, the accusation is up, but they can always come back and reissue a warrant.
When do you show that the warrant was issued on the possession of a controlled substance if it was different from the date that he was admitted to jail?
According to this, the second time when he came in, 12/23/19, it states that the warrant was issued 10/3/19 by Judge Holmes for that possession of controlled substance.
Is this in the jail records anywhere?
Repeat that.
Is that information in the jail records anywhere?
It's on the warrant that was issued. We keep the warrant information in the whole notes. It's in the whole notes.
You're certain that that was the first warrant that was issued for this misdemeanor offense?
According to this paper, that's when he came to jail on that warrant.
Well, reserve the right to ask for the question.
Further questions?
Okay, state doesn't have any further questions. May this witness be excused? Okay, Sergeant Granger, this will conclude your testimony. Thanks for your testimony, and you are excused, and have a blessed day.
Thank you. Y'all do the same.
Your Honor, that information was not in the discovery I received from the DA's office.
Okay, so Mr. Lawrence, you have anything else?
Your Honor, for now, I would prefer that we let this, that you not grant or deny the motion and let me research the records a little further. Give me a little time to research the records a little further.
Research what records?
Both the records I was provided by the state, by the DA's office, as well as any further records that the jail has. Your Honor, if you want me to show you on here,
Well, Mr. Lawrence, you had, Ms. Granger, on, cross-examination. You could have, asked her about any other records that you think you need. I assume by her being there, she had the records in hand. But you did not do that. But again, Mr. Lawrence, you have an argument, or do you have any other evidence you'd like to present?
well, all right, Your Honor. Even with the, her claim that the warrant issued on October 3rd of 2019, for, apparently, the records do show a warrant was issued, but it doesn't say for what, or whether it was a successive warrant. But even with that taken in mind, all the other records that I received from the DA's office showed that he was arrested back on in 2018, on July 12th of 2018, for possession of a controlled substance. And that's the sworn affidavit of the arresting officer. And so there's a considerable issue here about what he was serving time on. And I would simply like to just, if you could just suspend action on this particular motion until I have more time to research the arrest records, because the arrest plainly showed that he was arrested on July 12th. The arrest records plainly showed he was arrested on July 12th for possession of a controlled substance. In fact.
Well, yeah, are you finished?
Yes, Your Honor.
Mrs. Ramos?
Yes, Your Honor. Mr. Lawrence has had time. He's the one that's filed motions, briefs on the motions on this. And he had Sergeant Granger, who would have been the best person to ask about any additional records that may be at the jail. She clearly testified and explained to him and to the court how the accusation works, and that he was up on his accusation after 3 days. And then until the case is filed, that warrant isn't issued, and the warrant was issued when it was signed by you, Judge Holmes, on October 3rd, 2019. And then he was picked up on that on December 23rd, 2019, and he served until he bonded out. So, and she testified to how much time. And the state's argument is that based on that, the state, the DA's office, the judge, Mr. Lawrence, we all don't calculate the credit for time served in a case. The sheriff is the one that calculates the credit for time served in a case. And there's a case, Jones v. State, 176 Southwest 3D 47, and it's out of the Houston, the appellate court out of Houston, the first district, and it's from 2004. And it says in it that the judge has no authority to interfere with the sheriff's authority to decide what good time or work credit to award a defendant serving a county jail sentence. And Ms. Granger is a employee of the sheriff, and she told the court what the calculation for time in this case would be. And also, as the court pointed out earlier, and as I observed myself, most of the cases that were cited to in the briefs were for non-protoncs that were done after judgments. And so a non-protonc is not proper in this case. Neither is a dismissal, or unless the state were offering credit for time served, which we have not. We're not even getting into what the state has or hasn't offered in that. But He certainly has not served over a year time as Mr. Lawrence presented to the board.
Your Honor, if I may,
Yes.
I've discovered the sworn statement of Deputy D. Janice.
And I'm going to
Concerning
object
the
to that
arrest?
coming in or any statements from that coming in without the witness available to testify to it.
Well, we can have the witness later, Your Honor.
Objection
Before we
sustained.
decide anything today, we might as well note that Mr. Janice states,
Your Honor, I'm going to object. He's trying to get it in as hard as he can, and you sustained my original
Oh, yeah, objection
objection.
sustained. So any information on that affidavit should not be mentioned.
Your Honor, if she is willing to take the risk of asserting that he was not charged with possession of a controlled substance, which the deputy called Xanax.
Your Honor, he's trying so hard. I'm going to object again. He keeps trying to bring in the testimony of the deputy, and you
Objection sustained.
sustained.
Okay, you have anything else?
Well, Your Honor, I'd recommend that you hold off on deciding this matter because it appears that he was charged with this, or he was both arrested and charged with it back then, as of July 12, 2018.
Okay. Anything else?
That's-
Okay,
that's-
now, first of all, the court does not get involved. This is pre-trial issues, okay? This is negotiation between the state and the defense. The court does not get involved in negotiation between the state and the defense. You asked for a dismissal, saying that this gentleman served his time. You haven't given the court any case law to support your position, talking about that he served over the amount of time that is in that's in the punishment range, and you're asking for it to be dismissed. And I think the word that you used is that the court should use review with common sense. The court is not going to review with common sense. The court is going to be reviewed with the law and with the statutes and the law in mind. And when the court applies the facts of this case to the statutes and the law, first of all, you did not present any of the law or any statutes on your motion to dismiss.
They're in my
The
brief.
second, I read the brief. You're asking for a blanket dismissal saying that the guy served more than the time that is in the punishment range.
Mhm.
Okay, that's one issue. The other issue is you're asking for a non-pro-tunc. There's no judgment in place for the court to correct an error. Okay, and so the court is not, and you cite no cases saying that the court can do a non-pro-tunc on a judgment that hasn't even been put in place. How can you correct an error that hasn't? It's kind of like an imaginary error in the future that you want to be corrected before it is even signed in order. So
Your
with
Honor,
that,
there is a case in my brief where the Court of Criminal Appeals says on any of these back time things
But-
that it has to be a non-pro-tunc.
and the words and just looking at your brief, they said requires a constitutional guarantee is against multiple punishments for the same offense. You say absolutely requires the punishment already. And then you stated that under Texas law, the trial court may issue a non-pro-tunc order authorizing proper credit. That's after the fact when the person did not get the proper credit. That's not before the fact. We don't know what's going to happen.
All right.
And so the court doesn't even have, jurisdiction to sign a non-pro-tunc order. There's no case law to sign a dismissal in this case. And then the third thing is the court does not get involved in the negotiation between the state and the defense. So at this point, the court cannot make a ruling saying that, what you're asking for is what I'm saying. So based on that, the court is going to deny your request. Now, you're still in negotiation with the prosecution, and it may come up later on. I don't know. But at this time, the court is not in a position to one, get involved in negotiations between the state and the defense. The court is not, doesn't have authority at this point to authorize a non-proton, and there's no case law to substantiate or to support your position that this case should be dismissed. So at this time, your motion will be denied.
All right, Your Honor, please note my exception to the ruling of the court.
It shall be noted. And just for the record, with the transcript, the court did take note of testimony that was made from the witness, as well as the arguments and statements that have been made by counsel into consideration and coming to this conclusion, as well as case law and as well as statute. Okay, and I think the case that the state cited involves the statute 42.03, section 2A, and it talks about Jones v. State. The judge has no authority to interfere with the sheriff's authority to decide what good time or work credit to be awarded. And that came from the fact that you had asked for good time credit, I think, in your motion.
Your Honor, I would request that the brief be included in the record.
Yes, it was filed. It's included in the record.
Yes, Your Honor.
Okay. And it should be noted in the record that the witness stated that Mr. Fink was arrested. The offense occurred on July 12, 2018, and the accusation was up July 15 of 2018. Mr. Fink was rearrested on December 23rd of 2019. He served 1 day. And in this case, that the accusation was up for the 3 days was filed on October 3rd of 2019, but he wasn't arrested until December 23rd of 2019, and there was no evidence as to how long he stayed in jail before he bonded out, according to the evidence of testimony that I heard. I don't think there was no mention of when he bonded out after December 23rd, 2019.
Your Honor, does the court have records of what offenses he was bonded out on?
Well, the court is not in a position to, give records or anything. We're not the record keeper. I mean, I think you talked to Mrs. Granger. She had the paperwork as to when he bonded in, bonded out, and all of that information.
Well, if his bondsman has different records, is what I'm saying.
Oh, I don't know, but at this point, your motions at this time will be denied.
All right, thank you, Your Honor. And please note my exception.
Yes.
Do we have another setting in this case?
We can give you a reset. Is there a setting? We'll reset it for 30 days. Stand over here and get your reset. Once you get your reset, you'll be free to go. And Mr. Fink, you have a blessed day. And Mr. Lawrence, you have a blessed day as well.
Thank you, Your Honor.
Okay. Okay, Mr. Gilthorpe.
Yes, Judge.
We have Ms. MTRP.
You're gonna stay there.
We're on a record in cause number 320708, case is filed in the state of Texas versus Cassie Lynn Kerbo. I have before me a motion, a first amended motion to revoke the probation. Ms. Kerbo, would you please raise your right hand? Ms. Kerbo, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Okay, Ms. Kerbo, you may put your hand down. How you doing, Ms. Kerbo? Okay, Ms. Kerbo, thank you for being patient with us. This morning we had a long day. Ms. Kerbo, you're here with your attorney, Mr. Jared Gilthorpe. Mr. Gilthorpe, how are you doing?
Doing well, Judge.
Okay, Mr. Gilthorpe, I have before me a first amended motion to revoke the probation. And in this motion, it states that on November 27 of 2018, that Ms. Kerbo, you were found guilty of the offense of driving while intoxicated, and your punishment was assessed at 180 days confinement in Jefferson County Jail with a fine of $500. And the confinement was probated for 2 years. On January 30th of 2020, the state filed a motion to revoke your probation. In this motion, there are 9 allegations. The first allegation alleged that you committed the offense of public intoxication in that on or about the 22nd day of June 2019 in Jefferson County, Texas, that you did and dare appear in a public place while intoxicated to a degree that you may endanger yourself or another against the peace and dignity of the state and in violation of condition 1 of your probation order. Is that true or not true?
True.
Allegation 2 alleges that you failed to report to the Jefferson County Probation Office as ordered by the court. Let's see. Ordered by the court on. That must be on. Okay, it's a typo. On January 10th of 2020, as directed in violation of your probation order. Now, state, I see here, when I read it, it says, Cassie Lynn Kerbo failed to report to the Jefferson County Probation Office as ordered by the court, and it said Thon, Thon, January 10th, 2020, as directed in violation of condition 4 of your probation order. I don't know if it's
The state would like to either orally amend it, or if not, we can abandon that count, either way. If the court has a problem with the typographical error, because
Okay.
typographical error is simply, is not of substance in this.
right. So you want to abandon it, or do you want
We
to,
just, if we could orally amend.
you want to, you have any objections to the
No
oral amendment? Okay. Okay. So I'll read it again. It says, Cassie Lynn Kerbo failed to report to the Jefferson County Probation Office as ordered by the court on January 10th, 2020, as directed in violation of condition 4 of the defendant's probation order. Is that true or not true?
True.
True. Allegation 3 alleges that you failed to pay court assessed fees as ordered by the court, and as of July 30th of 2019, you was $370 in arrears in violation of condition 8 of your probation order. Is that true or not true?
Your Honor, I believe the state was going to abandon.
Abandon number 3. And number 4, it states that Cassie Lynn Kerbo failed to immediately report to the probation officer his address as ordered by the court in violation of condition 11 of the probation order. Is that true or not true?
True.
Allegation number 5 alleges that Cassie Lynn Kerbo failed to abstain from the use or possession of any drugs except those taken or possessed under doctor's orders as ordered by the court, in that on or about January 13 of 2019, Cassie Lynn Kerbo provided a urine sample for a scientific analysis that showed the presence of the metabolic byproducts of marijuana, amphetamines, methamphetamines, and ecstasy in violation of condition 12 of the defendant's probation order. Is that true or not true?
True.
Allegation 6 alleged that Cassie Lynn Kerbo failed to never become intoxicated or be under the influence of any intoxicating substance on or by January 13 of 2020 in Jefferson County, Texas, the said Cassie Lynn Kerber then and there became intoxicated and under the influence of an intoxicating substance in violation of condition 13 of the defendant's order. Is that true or not true? Allegation number 7 alleges that Cassie Lynn Kerber failed to perform the community service hours required as ordered by the court in violation of condition 18 of the defendant's probation order. Is that true or not true? True. Allegation number 8.
John,
Huh?
I believe the state is going to abandon the rest of those allegations.
Oh, 8 and 9.
Yeah, we feel like we've reached a level that's sufficient for the court.
Okay, now, Ms. Kerbo, the state is abandoning allegations 8 and 9 in your probation order. Okay, so in total, the state is abandoning allegation 3, allegation 8, and 9. And so therefore, Ms. Kerbo, you pled true to allegation 1, 2, 4, 5, 6, and 7 freely and voluntarily? And you pled true to these allegations because they are true? Okay, Miss.
7 noted in the
7?
7 in the report.
Oh,
I only had 1, 2, 4, 5, and 6.
Okay, then we will abandon 7.
yeah, 1, 2, 4. Okay, so you're abandoning 7 as well?
Yes, Sean.
That's 1, 2, 4, 5. Okay. So, Ms. Kerbo, are you pleading true to allegations 1, 2, 4, 5, and 7, 6, excuse me. Let me repeat that again. 1, 2, 4, 5, and 6 freely and voluntarily?
Yes, Your Honor.
And are you pleading true to these allegations because they're true?
Yes, Your Honor.
Ms. Kerbo, I have before me what is marked as State's Exhibit number 1. Ms. Kerbo, do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, Ms. Kerbo, are these your initials?
Yes, Your Honor.
And on the next page of the same document, Ms. Kerbo, is that your signature?
Yes, Your Honor.
And on the next document, I have before me is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is that your signature down here?
Yes,
Okay, and at the top, there's one box that's checked. It states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
sir.
Now, Ms. Kerbo, prior to signing and initialing these documents, did your attorney, Mr. Gilthorpe, go over these documents with you? And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Ms. Kerbo. Now, state, I have before me State's Exhibit number 1.
So we'd like to offer State's Exhibit number 1.
Any objections?
No, Your Honor.
No objection, State's Exhibit number 1 is admitted. Mr. Gilthorpe, you've advised and counseled Ms. Kerbo. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Kerbo, your attorney, Mr. Gilthorpe, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Ms. Kerbo, I'll accept your plea of true to allegations 1, 2, 4, 5, and 6. I will also find that you are mentally competent to stand trial. And I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your probation and your probation is hereby revoked. Ms. Kerbo. Okay, excuse me, state. Do we have a plea bargain agreement?
Yes, Your Honor, we do.
And what is that agreement?
The state agrees to allow Ms. Kerbo to serve 60 days in the Jefferson County Jail, and her time will start tomorrow at 6 p.m.
Will she turn herself in on tomorrow?
Yes, Your Honor.
Now, she gets credit for any time that she's already served,
Yes,
that
Your
she's
Honor.
entitled to get by law?
Whatever she's entitled to by law.
Okay, so, Ms. Kerbo, the state is offering that you serve 60 days in the Jefferson County Jail. Ms. Kerbo, you'll also be required to pay court costs of $127. Ms. Kerbo, would you be able to pay the $127? You will? Ms. Kerbo, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer, in your case, is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Ms. Kerbo, I'll follow the plea bargain agreement that you've entered into with the state. Ms. Kerbo, you'll be sentenced to 60 days in jail. You'll be given credit for any time that you're entitled to get by law. You're required to pay the court costs of $127. And your time, well, you will turn yourself in on April 10th of 2021 at or before 6 p.m.
Yes, sir.
Okay, Ms. Kerbo, you can stand on the X where your attorney is standing. Follow the directions of the court clerk. And once you finish here, you'll be free to go. She's gonna give you the commitment paper that you need to bring with you when you turn yourself in. And you have a blessed day.
Thank you.
And Mr. Gilthorpe, you have a blessed day as well.
Thank you.